Hi, everybody. Welcome back to Above the Haze. With me today, Katherine Tucker, Director of Advocacy, National Psychedelics Association. She spent the last 35 years in advocacy to protect the rights of dying patients. Wow. Welcome to Above the Haze, Katherine. So good to have you here.
Thanks so much. Happy to be here.
So, Katherine, you are, well traveled and well followed, and I appreciate a lot of the work that you've been doing over the years, whether it's been in complex litigation, an advocate in the different spaces for palliative care, and in particular, the death and dying frameworks here and our understandings and rights that we may or may not have, but should talk about and figure out. Um, but I'd love to kind of hear just from you, like, how did you get to now? And why is this work meaningful to you?
Yeah. Well, thanks for that question. I would not have predicted that I would be involved with psychedelic related advocacy. I'm not a psychonaut myself, but I have spent a lot of years advocating for expanding choices available to terminally ill people. And when I started reading about the amazing findings in the clinical trials with psilocybin for relief of anxiety and depression in dying patients, and how a single guided session could bring immediate, substantial, and sustained relief, I really was excited because what I knew from my 3 decades in the front lines of efforts to improve end of life care is that we had made a lot of progress in a lot of domains. So, for example, huge strides in methods and modalities for pain and symptom management, expansion of hospice care, the ability of patients to choose the option of medical aid in dying, the option for palliative sedation. There are a lot of strides that empower dying patients with more and better choices. But the one tool that was missing from the palliative care toolbox was something for relief of non-physical suffering. And that's what the psilocybin assisted therapy offers. And, it's so important because when we are in the hotly contested debates, whether it's in litigation or in a legislative arena, about, for example, whether dying patients should be able to advance the time of death by ingesting medications prescribed by their physician for a peaceful death. Um, Nobody wants to imagine a patient would make that choice because they had unrelieved anxiety or depression. So, advocates really across the spectrum on these issues can agree that adding this tool to the toolbox is important, and hence the work that I've been focused on for the last couple of years.
Yeah, thank you. I really appreciate that navigation. I want to pick up on a few things and kind of explore it with you. Um, the concept of the right to die, which could include a medicated death, a pill that could end your life, or a substance that could end your life. That's its own particular issue. And then you've got the issue of psychedelic, therapeutic psychedelic for the dying, um, and which could relieve, or does, or is shown to relieve, the anxiety and stress of the dying process. I wonder, are you seeing, do you predict that more of the anxiety relief, stress relief, psychedelic therapy might lead to less desire, less need for the former, the end of life pill, so to speak?
Well, it's such an interesting question. We don't know. There's no data bearing on that question at all. But we have seen some thought leaders in the hospice and palliative care world take the hypothesis that yes, if patients who thought they wanted to advance the time of death had psychedelic assisted therapy, they might not pursue that course. And so, that, of course, is one possible impact of having that therapy. But I think equally it might go the other way, where someone felt so resolved to their impending death that they were ready to embrace it earlier. We simply
Mm.
don't know. I will say the hypothesis has been made that it could reduce interest in aid in dying, but we don't have the data. Now, it's interesting with Oregon opening its state legal program. And of course, Oregon was an early adopter of a so called Death with Dignity Act. It was the first state, again, pioneering in the health policy arena back in 1994 when it was the first state in the nation to adopt a Death with Dignity law. And now that law has been implemented without interruption since 1998. It was embroiled in litigation before it took effect, but since 98, it has been operational. So there's certainly a well established practice with medical aid in dying in Oregon. And now Oregon has pioneered with the Psilocybin Services Act. And you could imagine a study that sought to elicit information and evidence on whether psilocybin assisted therapy impacted a dying patient's interest in medical aid in dying. I hope that research gets done. I think it's a really interesting question.
I wonder if we're going to see a coupling of the two medical entities, uh, those that perform the death process and those that perform the psychedelic therapies.
Right.
It might seem like a natural fit together for some practices potentially.
Well, yeah, a couple of thoughts on that. One is in a state where medical aid in dying is available, so meaning dying patients can request and receive a prescription for medication from their physician that will enable the patient to precipitate a peaceful death. In those states, which, by the way, now about a fifth of Americans across the country live where this is possible. Um, it may become best practice that patients expressing interest in medical aid in dying be offered psilocybin assisted therapy as kind of a tool to see if additional palliative measure impacts their thinking. So it could become a best practice to offer that. But I think also the suggestion you make is really quite interesting, and I have heard a couple of others make it, and that is it possible that a person who is approaching death through terminal illness, who has their prescription for medical aid in dying, would want to choose to ingest that and precipitate a peaceful death when they were dosed on psilocybin? Aldous Huxley, I think, is one of the famous examples of someone who took a big dose of psychedelics as he was dying. Um, so maybe that will become something that some choose. And I have heard clinic suggested for that specialty.
Yeah, I mean, profound for sure. I want to kind of just pivot into more of like the personal, like, why do you care so much about this? Why has this been your work?
Yeah, I mean, I think that I got involved very early. In 1990. Washington State was the first state to put a death with dignity measure on the state ballot through initiative. And I was a brand new lawyer right out of law school, and I wanted to do some interesting public interest work, and I became campaign counsel to that
Oh,
initiative
interesting.
campaign.
So you learned
So
about
then, yeah,
inside.
yeah, and I found the issue so interesting. It really is at the intersect of law and medicine, and invokes a lot of fascinating issues about who has autonomy to make medical decisions for an individual. Do we repose that in the individual and protect it? Which, of course, was the foundational argument to a pair of cases that I developed and took to the US Supreme Court in the mid 90s, Glucksberg v. Washington and Quill versus New York, where we claimed that the choice of a dying patient for a peaceful death with physician assistance was a personal right of liberty and autonomy that should be respected. And we won those cases in the Second Circuit and the Ninth Circuit Courts of Appeal. Um, and there was no split in the circuit, but interestingly, the SCOTUS took the cases, set them for hearing in tandem, and then opined that it would not go that far at that time, but did invite the states to grapple with the issue and kind of kicked it back to the laboratory of the states, leaving the door ajar for a future successful liberty claim. Although, in the interim, with the evolution of what's happened on the SCOTUS bench, no prudent lawyer would take an individual liberty claim in front of that bench.
Yeah. When I trace back my own origins on the subject, I'll be 40 this month. And one of the most influential moments was the Jack Kevorkian trial when I was growing up, and the death machine and all the stuff, and
Right.
the narrative around it, and the media focus and all those things. I don't know how old I was exactly, but certainly had an important impact. And I think
Yeah.
what a lot of my folks in my generation probably feel similarly, that it opened us early to the concept of, you know, who is it that gets to make a decision with respect to your essential question of life here?
Yes, right.
We've
Well, we did have a very long line of jurisprudence from the Supreme Court of the United States, from issues bearing on family composition and reproductive rights, that spoke in resounding terms of a sphere of private behavior that was protected from usurpation by the government.
yeah,
That is now threatened, of course, with the overturning of Roe, which was part of that line of precedent. So that's really concerning. And
interesting.
back to sort of the lightning rod that was the conduct of Jack Kevorkian, I think that most people, and certainly most people dying of terminal illness, want to be receiving care from a well credentialed, highly credentialed, and capable, responsible clinician. And most people don't want to resort to a rusty van in the back alley with
Of
a pathologist. Yeah, so I think one of the impacts of the Kevorkian public spectacle was growing support for moving out of the back alley and into a legal program where dying patients could approach their treating physician for assistance in achieving a peaceful death.
Since Oregon came online, how many states have followed suit, to your
So
knowledge?
that was a lot of the work I did for many years in my career. We're at 11 states now and the District of Columbia.
Oh, wow.
Most all of those states have a state statute adopted either by initiative or through the traditional legislative process. But one state adopted access to medical aid in dying through a state Supreme Court decision, and that was the case known as Baxter versus Montana. So it's kind of a mix of how states protect this choice. But yes, it is an increasingly available choice and it belongs on the menu. I mean, one of the great benefits of modern American medicine is it can do a good job of staving off death. But for some people, they find themselves trapped in what seems too long of a dying process, and they're ready to achieve a peaceful death. And that's where this option becomes so valuable.
Yeah, absolutely. And just kind of from a therapeutic psychedelics advocacy perspective, I wonder if those 11 states uh, might be the right type of state to consider psychedelic therapies with that in mind.
Well, very possibly. But again, my work in recent years has focused on creating federal safe harbor
Very.
because, as you know, Schedule One substances are federally prohibited for any purpose other than research. So I became concerned watching what was unfolding, and I had a role in working to see the Oregon measure adopted. I was living in Oregon at the time, and I worked to bring end of life clinicians and patient community to support the measure. Having said that, it's nearly impossible for clinicians to be involved in providing psilocybin assisted therapy because Oregon's law is only a state safe harbor, not a federal. And for physicians who hold prescribing privileges and DEA registrations, they cannot step outside the bounds of federal law, or they risk losing those privileges, as well as potential criminal penalties, jail, and fines. So that really stimulated my work to create a federal safe harbor. And that work has now two different fronts that are oriented to achieving the same goal. First, what we did was went to the DEA on behalf of a palliative care physician and several of his cancer patients, asking how the DEA would accommodate existing state and federal right to try laws. These laws are meant to allow people with life threatening illness to access investigational drugs that meet certain criteria. And psilocybin meets those criteria. So it should be available now to clinicians who want to offer it to their dying patients. And yet the DEA has interposed itself to thwart and nullify this existing state and federal law, which is really out of its lane. The DEA is a law enforcement agency. It is not meant to intrude into and control the practice of medicine. So it's well outside the bounds of its authority in obstructing operation of right to try laws. So that is some of the litigation, and that's referred to as AIMS, AIMS versus DEA. Um, the other thing we've done that is oriented toward the same goal of opening access for physicians to be able to have medicinal use is to petition the DEA to reschedule psilocybin off of Schedule 1 and onto Schedule 2. And that petition was denied. And we filed a lawsuit challenging that denial, which we just won. And so the DEA was smacked down by the court and told this denial is insufficient. You have to do better. And hopefully, on reflection, what the DEA will do on remand is what it should have done, and that is ask the FDA for medical and scientific opinion about rescheduling. And we already know what that opinion is. How do we know? Well, the FDA has granted breakthrough therapy status twice for psilocybin. So we know it considers this an important investigational drug.
I'm going to ask you to opine, if you would, or speculate. Why is the DEA acting this way? What's driving it? What's its primary thought process here?
I can only speculate that it is a knee-jerk reaction that whenever access to Schedule 1 drug is sought, it is denied. It's just the automatic default of that agency. No matter how compelling the argument, here we confronted the agency with existing state and federal law that provides for access, and yet it still denied it without any authority to do so. And on the rescheduling petition, instead of getting that scientific and medical opinion from FDA, it just said no. It has an automatic default to deny. And that's really frustrating here because access should be available under these laws. Rescheduling is appropriate under any of the tests. And so it's really frustrating. And at the same time, I don't know if you noticed, but this week in the media was an article disclosing some of the conduct under the Oregon law by facilitators and service centers that seems quite dangerous potentially. And yet you do not see any DEA enforcement as yet, where probably it would be warranted. At least as you read that media coverage, you think this looks dangerous. So declining to enforce in that arena and then obstructing access to supervised medical use by a licensed physician with a DEA registration, it makes no sense.
Yeah, no, it doesn't make sense. But you do highlight a really important subtopic, which is psychedelics is becoming mainstream. It already is mainstream. It's entering the regulated models coming from west to east. It's reinvigorated traditional communal uses, indigenous uses, religious uses, a lot of different uh, um, perspectives out there on this. Obviously, the federal government and state governments, localities have a interest in public safety, and in a, I would imagine, most interest in a smart rollout of all of these different things that are still being defined and created. How concerned are you with the pace of the overall psychedelics plant medicine space? Are you concerned that it may impede um, targeted areas that you're interested in?
Well, I mean, I think one of the things that could happen is that the DOJ, as it did eventually in the cannabis arena, could adopt a policy clarifying its intention with regard to enforcement of federal law with regard to psilocybin, for example, in Oregon, and that if certain measures were in place to legalize and regulate, that the DOJ would take a hands-off approach. You know, we eventually saw that happen in cannabis. That hasn't happened yet, and so there is no clarity, and it makes it difficult for operators to proceed with any sense of certainty. And instead, what appears to be unfolding in Oregon and likely in Colorado is a hope that DOJ and DEA will refrain from enforcement. But we don't know that that's true. And I like to remind people about what happened quite recently with the effort to open safe injection sites, which were intended to reduce opioid overdose by providing a place where people could do injection of opioids in a supervised setting so that there could be administration of antidote medications and lives saved. And yet, the DOJ did undertake injunctive action in the Safe House case and was successful. Even though, you know, the lower court ruled in favor of the Safe House on the grounds of laudable public health purpose, the Third Circuit said no. You know, the law is clear, and that's the crack house provision of the Controlled Substance Act, which prohibits drug involved premises. And certainly, you know, a service center in Oregon where psilocybin is available is a drug involved Schedule 1 premises. One of the really interesting things that's been pointed out is that because all the participants under the Oregon law are licensed by the state, and there's been very public disclosure of the names and locations of the service centers, it would be just fish in a barrel for an enforcement action if DEA and DOJ decide to pursue that. So I think that's a cautionary instance where it doesn't feel safe to just imagine that enforcement won't be taken.
I think you're right. We've talked a lot. I think the good try to just wrap things up now. You know, it's important work that you're doing, and that a lot of folks in the the social law um, segments of society are doing. I think all of these issues fundamentally follow under a freedom of your own consciousness, your own mind, your life, your individual independent liberties, and so on and so forth, and an evolving society. With where you've been and where you are now, how would you describe kind of that landscape, the underlying principles by which your work is an expression?
Well, I think there is complete coherence in how I see the work I'm doing and engaging in the psychedelic arena with the work that went before that. And it is all oriented toward empowering people with life threatening illness to have more and better choices as they manage that illness, as they confront the reality of death and make the transition across the threshold to death. So, for me, this is all of a piece. I realize, there are many, many other reasons that advocates are interested in opening access to psychedelics. But those are really, not in my wheelhouse. But, I will say I've seen some great coalitions emerging here. So, for example, in the work that I've been doing on behalf of terminally ill people, we were really gratified and grateful that the veteran mental health community has come in support of the work that we've been doing. Because, of course, another really important application of these substances is relief of PTSD in veterans. And
Yes.
so we did have veteran coalition amicus support on our in some of our AIMS litigation, and that's been great. It's another important perspective, and it's really concerning when veterans who served this country and in the wake of that service are so damaged that they can't function and they're considering suicide are having to leave the country they served to get treatment that enables them to return to a high functioning status. So it's been an evolution of coalition building in this arena that I hope will achieve the result that we're driving toward, which is access with federal safe harbor for those who could benefit.
Thank you so much. As a Marine Corps veteran who's lost a number of brothers and sisters to suicide, I appreciate your sentiments there. Katherine Tucker, thank you for joining me on
Pleasure.
the Haze. I really hope to see you continue this great work out there. I think it's important, and I appreciate what you're doing.
A pleasure. Thanks so much.